Okay, lovely. Thanks, Declan. And good morning again, everybody. Nice to get the opportunity to talk to you. I hope you've enjoyed the course. So what I'm going to do this morning is I am going to take you through the mock paper in law. Okay, so there's 4 questions. I'm going to take you through how you might answer those if they came up on the real exam. Okay. There's 4 long questions, and then there are 50 multiple choice ones on the mock one. And then what I will do is I will put away the mock paper, take out the real one, and I will give you some insights as to what to maybe cover off. This can be to help you narrow down a little bit the material that you cover off for the real exam. Okay. Now, the first thing I'm going to say is I'm not going to cover off the 50 multiple choice questions, okay? Because if we do that, our time is going to be gone before we get on to any of the long ones. So what I will do is I will email you the answers to the 50 multiple choice questions. So that way you have them. If you have any questions for me, you can come back to me, okay? But I'm going to dedicate this session to the 4 longer questions that we have in law to give you an idea as to how to answer those, okay? So I'll do that after the session is over, okay? So on the mock paper for law, when we move on to the longer questions, so there's 4 longer questions here. You need to do 2 of them on the day. The first question relates to contract law, okay? And the question is, Paddy in Dublin wrote to Mary in Cork offering to sell his Mercedes car for €15,000. On receiving Paddy's offer, Mary telephoned him to say she would like to accept the offer, but because there was such a large sum of money involved, and because there were 1 or 2 more interested parties, Paddy said he wanted Mary to confirm her acceptance in writing. He said if he received her acceptance the next day, which was Friday, he would go ahead with the sale at €15,000. Mary immediately wrote out her acceptance letter and posted it to Paddy in Dublin using Standard Post. Paddy received it the following morning, Friday at 11 a.m. However, on Thursday evening, Paddy had received a better offer from a local guy, and he wrote to Mary to withdraw the offer. This letter missed the last collection and was not received by Mary on Friday morning. Okay, so the question that we're trying to establish here is there a contract? And if there is a contract, what potentially can be done in order to put the parties back where they should have been, which is the aim of contract law. Okay. All right, so what do we need for a contract? We need an offer, we need acceptance, we need consideration, and we need intention to create legal relations. Okay, so those are the first things we're going to look at. We're going to look at the postal rule as well, but we'll come to that in a minute, okay? But before we look at the postal rule, we need to ask ourselves, okay, well, is there the prospect of a contract even before we look at the actual timing of the letters, okay? So the first thing to ask ourselves is there an offer? Okay, so if we look at the facts again, Paddy in Dublin wrote to Mary in Cork offering to sell his Mercedes car for €15,000. So that sounds like an offer to me, okay? Now, it is important to say, in answering these type of legal questions, it is good to, there isn't necessarily a right or wrong, okay? You can come to a conclusion and say, okay, there's, I don't think there is a contract and here's why I don't think there's a contract. Or you can say, I do think there's a contract and here's why I do think there's a contract. And both answers can be equally right, okay? The one thing I would steer away from is kind of suddenly changing your mind and saying, okay, it appears that there is offer, acceptance, consideration, and intention for legal relations, and therefore I deem there to be no contract. I have seen that in answers before, and your reaction is kind of, sorry, what? You said there's all 4 of them, but yet you're saying there's no contract. You need to immediately then clarify why there is no contract. But the first point is, okay, we're looking for an offer. The first line of it says, Paddy wrote to Mary in Cork offering to sell his Mercedes car. That's Paddy writing to Mary and nobody else and saying, okay, do you want to buy my car? That sounds like an offer to me. Okay. Is there acceptance? Okay, so on receiving Paddy's offer, Mary telephoned him to say she would like to accept the offer. Okay, so there is certainly a degree of acceptance there. Paddy, because it's such a large sum of money, says, okay, well, I'd like acceptance in writing. And Mary immediately writes out her acceptance letter and posts it to Paddy. Okay, so there's no indication of delay in the acceptance. So we have an offer and it looks like we have acceptance as well. Okay, we have acceptance by phone, and then Mary sits down, writes the letter and posts it. Okay, so that indicates acceptance on potentially 2 fronts. Is there consideration? Okay, so Paddy is talking about a car. So he has the car and he's going to give it to Mary. He has offered it for €15,000. Mary has indicated she accepts and she's going to go ahead with the sale at 15,000. So yes, there appears to be consideration. So, a bit of discussion around the offer and the acceptance would be good, and kind of say, okay, if Paddy did this, then that would change things. If Mary did that, then that would change things. So a bit of discussion, the way a judge would discuss things. Judges don't just come out and say, I find for this side and walk back out again. They do explain why they feel this, and they do explain other alternatives. So, an element of that, particularly on the offer and the acceptance piece, would be good. Consideration, you probably don't need to discuss an awful lot, because there's 15,000 there. There's a car. There's certainly indication of consideration. Okay. And then the last thing we're asked to check in terms of whether a contract has been formed is intention to create legal relations. Okay, so Paddy wrote to Mary in Cork. Okay, so that's a bit more formal than maybe other forms of communication, especially these days. Mary telephoned him, and then he indicates he would like her to write back. So we have potentially 2 letters, and then later on there's a discussion of him withdrawing the offer because he's got a better one, and he's written to Mary again. So there's probably about 3 letters mentioned in the relatively short paragraph there in terms of the facts. So would letters going back and forth suggest intention to create legal relations? Yeah, they probably would. If the 2 of them were meeting in a bar late at night and they had a number of drinks, and then they kind of laughingly discuss kind of one buying the car off the other, does that suggest intention to legal relations? Maybe a bit less. Okay. So purely in my view, although I'd be open to argument on the other side, for me, there's offer, there's acceptance, there's consideration, and there's intention to create legal relations. So for me, there would be you have the basic principles there for a contract. Okay. So the other thing you would need to discuss there is, okay, because you got the postal rule. Okay, that's how Mary accepts it. He looks for it. Paddy looks for it to be done in writing. Mary writes out her acceptance and posts it. Okay, and then you also have discussion about Paddy writing to Mary and indicating there's a better offer on the table, so he withdraws the offer, and the letter misses last collection. So you have the discussion on the basic principle in terms of the postal rule is once the letter hits the post box, that's deemed to be acceptance or revocation, depending on the letter that is being sent. Okay. You can then get into discussions. Okay, well, was it posted in a post office that where where the person behind the counter knows Mary well and can vouch for the fact that this was done at 4 o'clock in the afternoon, whereas Paddy's might have been put in the post at 5. Once it hits the post box and enters the postal system, that is the acceptance or the revocation. It's deemed to be in the hand of the other person. Okay, and you can explain that when discussing the postal rule. Okay, no, you can go into discussions and kind of say, okay, well, is there if there was an actual big trial on this, are you talking about taking CCTV kind of footage or kind of witnesses or whatever? But how you prove it, you can certainly discuss quickly if you wish. But those would be the basic principles. So I'm not necessarily saying that I'm 100% convinced that there is the basis of a contract, but you can get from the direction of the flow of my train of thought whether or not I would say it. So those are the type of things that you'd be looking to cover off. Okay. Any questions on that? Okay. All right. Well, we'll move on to question 2 then. So that was contract law. That's from module 1. Question 2 is from module 2, and module 2 is on company law. Okay. So the question under company law is this, and it relates to what a company can and cannot do. Murphy Limited have indicated in their company constitution that they will renovate houses and apartments and sell them at a market price. For 5 years, they continue this undertaking, and then, following review of costs and recent sales across the country, they determine that there is significantly more money to be generated by purchasing land and developing it instead. Without undertaking any changes to the company constitution, they embark on this new venture, borrow a significant amount of money from Loan Bank, and purchase their first plot of land. Outline possible consequences for this action for Murphy Limited. Describe how these limitations have been relaxed over time and what steps Murphy Limited can take to avoid this problem. Okay, so there's actually 3 questions, a small set of facts, and then there's 3 questions. 1, what are the possible consequences? 2, how have the limitations been relaxed over time? And 3, what steps could Murphy Limited take to avoid this problem? So the consequences first. So what potentially could happen if this scenario were to play out? The first thing that could happen is the transaction might be ruled to be null and void. Okay, the court might step in and say, okay, you can't do it. Okay, because there's nothing in your company constitution that says you can do the activity that you have borrowed the money for. Okay, so the transaction may be deemed to be void. Okay, now how difficult that is, and how, if such a scenario were to arise, the court would probably be looking for things to be put back the way they were. Okay, so if Murphy Limited have a field that they bought using money and they haven't spent the money, and all they need to do is return the money to Loan Bank, and the field goes back to whoever previously owned it, that's relatively straightforward. If they've gone ahead, I mean, if amount of time has gone past and they've gone ahead and they've started building on a field that they own but probably shouldn't own, it becomes a lot more difficult. In theory, the court could say, no, you need to knock down everything and put it back the way it was. Okay, so that's one option. It's not the only option, but that's one option. The transaction might be ruled to be null and void. Court might say, put everything back the way it was. Okay. The second thing is, second possible option is that Loan Bank could enforce a detrimental contract. So, I mean, you have to ask yourself, and they'd be open for discussion in an answer, who is likely to benefit from a ruling taking place. So, I mean, let's say the Loan Bank lent the money to Murphy Limited, and then they, after a little bit of consideration, they say, "Oh my God, this is a terrible idea. They're going to lose money. They're going to lose our money. We're not going to get the loan back." They could be the ones going to go into court and say, "Okay, let's try and make sure that they have to pay the money back before they embark on it and before they spend it." But that's one thing the court could do. The court could say, "Well, okay, yeah, Loan Bank did lend the money. The Murphy Limited are going to use it for something that they're not really entitled to do. But that's Loan Bank's tough luck, if you want to look at it that way." And they could say, "No, we know it's going to be a bit of a disaster for you, but you went into the contract in good faith. Therefore, we're going to rule that the contract stands." Okay, so that's a potential other scenario. The court could go the other way and say, "Okay, we know it probably shouldn't have happened, but Loan Bank are trying to wriggle out. It's we don't feel any sympathy for them. We're going to enforce the contract and let it go ahead." Okay, so that's the second scenario that could take place. The third scenario that could take place is the directors of Murphy Limited could be subject to injunctions restraining them from making the transaction. Okay, so you could have maybe a major shareholder in the company who decides, okay, this thing that you're embarking on is going to be a disaster. You don't have any right to do it anyway, so they might step in and try to get an injunction from the court to stop them completing the transaction, which would involve the money going across to Murphy Limited that they will then use to purchase and develop the land. Okay, so what would happen there is you could have a scenario that maybe the transaction was going to be good for both of them, but because of the objector, they can't go ahead with it. Murphy Limited might have to fight the injunction, so that'll involve some costs, and you could end up on the 9 o'clock news, so you're getting some negative publicity for the company. Okay, so those are the three things that are those are the three scenarios that probably, one of which is probably likely to happen in the event of that loan going ahead. Okay. So before I move on to the second part of that answer, which is how things have changed over the years, are there any questions on the first part? No. Okay. So in terms of the second part of the question was, okay, how have things changed over time? Or sorry, let me get the correct wording, which is describe how these limitations have been relaxed over time. Okay, so how have they been relaxed over time? 10 years ago, when the 2014 Companies Act was published, prior to that, you had to be very specific in terms of what you were going to do if you're a company. Okay, you said, these are the tasks I'm going to embark on when I'm a company, and I'm not going to deviate from these. And the reason for this is so that investors would have a good idea, okay, if I give this company €100,000, and if I invest €100,000 in this company, I know what they're going to use my 100,000 for. Okay. Now that was a bit restrictive. Okay, because times are more agile. Business has changed. Things move quickly these days. So as a result, the rules were changed in the 2014 Companies Act, which said, okay, you can maybe be a little bit less specific about what you're going to do. You can potentially, you have your constitution rather than the objects clause that you had before it. You can potentially say, as part of your constitution, listen, we're going to embark on any venture that we deem to be good for business and that will provide a return for the business, you can start framing things a little bit like that. So things relaxed a little bit in the 2014 Companies Act. They were quite restricted beforehand in that you had to say, this is exactly what I'm going to do with as a company. Now you can be a bit more liberal, and you can potentially just say, okay, well, we're going to embark on whatever ventures we think are going to be useful for making profit for the company, and as a result, things have gotten easier. It's gotten easier to do business. Okay, so that's how things have relaxed over time. In terms of possible defenses, which is the third part of the question, okay, so how could potentially Murphy Limited I don't know, either pro or post the transaction wriggle out of this, for lack of a better phrase? The first thing they could do is you could have a scenario where the directors were empowered to change direction of the company. So if something has been indicated in the company constitution that says exactly what I just did, that is, okay, if we the directors deem that a certain course of action is going to be good for business, we're going to embark on it. If that was put in, or was then added, in terms of stopping it from happening again, you could then have a scenario where it would be okay. You could also prove, if you're Murphy Limited, you could prove that Loan Bank knew that the transaction was ultra vires. Okay, so you could say, okay, well, yes, Loan Bank, yes, we are doing something that is not really within the power of the Constitution, but Loan Bank knew. We had several meetings. Here are the minutes of the meetings. We told them what we were going to do. They had a copy of our Constitution. They knew that we couldn't do what we were supposed to be doing, but they went ahead and lent us the money anyway. So if it were a Loan Bank trying to get the loan back, that would be a way of heading them off. And then the final thing would be, in theory, this would be a bit of a stretch, but in theory, you could show that the transaction was not legal in the first place. So you could show the activity was not legal. So we're going to go and rent it. We're going to go and build things from scratch and so on. If, for whatever argument's sake, the activity they were going to embark on is not legal, that would be another way where potentially Murphy Limited could maybe get out of the scenario that they're now in. Okay. So those are the type of things we'd be looking for. Long answer, there's a lot in it because there's 3 different parts, but those would be the type of things we'd be looking for if such a question were to come up in the real exam under company law. Any questions before I move on to question 3, which is on EU law? Nope. Okay. All right, so question 3, this one, if I remember, a short question, but longish answer. Okay, so question 3, which is on EU law, is this. The Commission wants to cut greenhouse gases across the EU. They settle on a figure of a 33% reduction over a 10-year period. Describe how this proposal would progress through the EU institutions to become binding on the member states. Okay, so the way that this would progress, and I suppose come to be a reality, is this. The Commission would start off with the consultative stage. Okay, so the Commission's the first player in the process. Okay, so they would be the ones that probably hatch this idea and say, okay, this is the way we feel the direction we feel the EU should go to combat climate change. So what they would do is they would start by discussing this with the various member states. Okay, and they would take the interests of the member states into account. Okay. And when I say they would take the interests of the member states into account, if, for instance, one of the member states was very reliant on maybe agriculture, okay, and agriculture was deemed to be a key player in relation to climate change, they would take that into consideration. Okay, so if they rely more heavily on farming, and maybe farming makes up 40% of their gross domestic product, whereas maybe in other countries might make up 10. The European Union, the Commission, would take that into account. Okay, so what could they do? Having taken that into account, they could potentially give those countries a bit longer to implement the directive. Maybe they could say, okay, well, maybe a reduction, instead of being 33%, maybe it's more like 20%. Now, that would kind of contradict if they did that, it would kind of contradict the directive to begin with, because the directive doesn't say 33%, but with the exception of, I don't know, say Ireland and France, it does say 33% across the EU. So it might be slightly contradictory, but those are the type of things they would begin to start taking into consideration. Okay. They would then start a consultative process with key players in the battle against climate change. So I suppose the type of players they might be talking with to be big business groups that are maybe heavily involved in industry, okay, who may be seen to be key pollutants. Energy groups to see how the energy requirements for the states could be met but reducing but at the same time reducing the reliance on fossil fuels. They would maybe meet with the farming organizations, okay, and say, okay, well, what can be done to maybe reduce the output there? They would meet with people involved in transport, probably on two sides. They would probably meet with people involved in transport on the motoring side to say, okay, what more can be done to reduce the impact of climate change from motoring? But they might also meet with representatives from public transport, okay, to say, okay, one, how can we keep the public transport as green as possible? And two, maybe how can we scale up the public transport so that there would be less of a reliance on cars, okay? So those are the types of groups that they would discuss, okay? That they would discuss the proposal with and see what I suppose parachutes would probably be needed in order to allow this to happen, okay? Following the meetings with the groups, the Commission would assess the impact by preparing impact assessments along with proposals and actions like the Commission would recommend undertaking to resolve them. And then these reports would be sent to the Parliament and the Council of Ministers to consider whether or not they would adopt the proposal on climate change. Okay, so that's the consultative process. Okay. They would then move on to the review stage. Okay, so once the proposal from the Commission is finalised, it is sent to the European Parliament and the Council to review the proposal and make amendments. This is similar. You might remember in Module 1, there's a discussion about how a bill becomes a law in Ireland. It goes through the Dáil. This is similar to the Dáil committee stage, okay, where they tinker with it a bit and say, okay, well, what changes do we need to make in order to make this practical, reasonable, enforceable, that kind of stuff, okay? If the Council and the Parliament can't agree on changes, a second reading takes place, okay? During the second reading, further amendments will be proposed, okay? So there will be, some horse trading and some discussions that'll try to get this over the line, with the option of states blocking it. So the Parliament can block it if the proposed legislation, if they can't agree with the Council of Ministers. If both institutions agree on the amendments, then the proposed legislation can move forward to be adopted. If they can't, then it goes back to a conciliation committee consisting of representatives from the Council of Ministers and the Parliament, and they will work together to try to find a solution. Okay. And then if it's passed, it'll be voted for by the Parliamentary Committee and then voted on by the Parliament. Okay. So that is how you would go about answering question 3 on European Union law. So the last one we have is tort, but before we get on to tort, does anyone have any questions on that? Okay, so the last question is on tort, okay? And the example that we have on the mock paper is the following. Okay, so Declan is a young teenager who's been bullied by another young boy, Rod, in his class in school. Rod has been taking Declan's lunch money and threatening to beat him up if he tells anybody. For months now, Rod has been making Declan's life a living hell. Walking home from school one day, Declan notices that a local farmer, Tom Brown, has left the gates of a field open, and being naturally curious, he wanders in. The field also contains a large barn, and it too is unlocked, so Declan wanders in there and noses around. He searches through some presses and finds a shotgun. The farmer has a license for the shotgun and is a member of the local gamekeeping community, a fact that is well known in the community. The gun is empty, but after a more thorough search of the barn, Declan finds some shells. He hides the gun and shells in a school bag and heads for home. The following day, Declan arrives in school and sees Rod playing in the yard. He takes out the shotgun, which is already loaded, turns it on Rod and shoots him, causing serious injury. Declan also suffered an injury himself because of the kickback from the shotgun. Rod's parents want to bring a negligent action against Tom Brown because they believe that any person who owns a gun should be legally responsible for the injuries caused by that gun. Okay? So there's a lot in there. There's a lot in the facts. There's also a lot in the questions because there's 4 different questions. Now, I will say, in case I forget to mention it, there will only be 2 questions on the tort part. Tort is on the exam. Not too surprisingly, but there will only be 2 questions. There won't be 4, so you probably have a little bit less in terms of writing. But while there may be 4 here, there's an element of overlap between the answers anyway. So I'll take you through them. To prove a successful negligent. The first question is, to prove a successful negligent action, what are Rod's parents required to prove? Okay, so we start off with the most basics that we got from Donoghue versus Stevenson. Okay, so we need to prove. Okay, we need to prove a duty of care. We need to prove there was a breach of the duty. We need to prove there was damage. And we need to prove that there's a link between the two. Okay. Now, so similar to the contract one, I mean, there's not necessarily a right or wrong answer. I'm happy enough to be convinced either way, as long as you can back up your feedback. But in terms of duty of care, okay, you're talking about a gun. Okay, so there's probably not a huge amount to discuss on that. Is there a very high duty of care when guns are involved? Yes. Okay, the laws of the country that you may be aware of separately requires you to kind of have a license for the gun. Gun needs to be locked in a gun safe. And it needs to, you can't have a scenario where the keys are just sitting on top of the gun safe. There are precautions that need to be taken when you're coming in contact with guns. Okay, so is there a high duty of care in relation to guns? Yes. If you're dealing with something like, I don't know, maybe feathers or something like that, would there be as high a duty of care there? No. Okay. All right. So it's guns. Yeah, there's going to be a high duty of care. Okay. Is there a breach of that duty? Now there's a bit more of a discussion. Okay, because you're talking about kind of, well, is the gun just left on the side of the road loaded? No. It is on the farmer's private land. It is in the barn. Is it in a gun safe? No. So you could argue that's a breach of duty. Breach of the duty of care. The gate is unlocked, the barn is unlocked. Is the gun loaded? No. So you could argue one side there. Are the bullets accessible? Because Declan ultimately found them. Yes. So is there a breach of duty there? You can decide. You can put forward the facts and you can decide yourself. Okay. In terms of, and you can link it to previous cases and say, okay, based on that, what was ruled in that case, that would suggest that the judge is probably likely to find this way. Based on this case, the judge is maybe likely to find the other way. Okay. Is there damage? Yeah, not a huge amount to discuss there. Declan has an injury himself from the kickback from the gun, so he is injured. Rod gets shot, so he is injured. So is there damage? Yeah, that's fairly conclusive and probably wouldn't really be argued from either side. Is there a link between the two? That's what you need to kind of show. It's that's what you need to kind of show. I mean, is it a case? And in order to do that, a couple of things that you need to bring into the answer is, first of all, the but-for test. Okay, but for the gate being open, would Declan be able to get the gun? But for the barn being open, would Declan be able to get the gun? But for the gun being in the barn to begin with, but for the shells being in the barn. So you can do but as you're going along, and then you can come to a conclusion and a suggestion as to whether or not negligence would stand or not. The other one to take into consideration is, what would a reasonable man do? Okay. I mean, I don't know how many gun owners there are in Ireland. I don't know how many of them have them properly locked up versus not properly locked up. But you can decide yourself, and you discuss yourself. Okay, what would a reasonable man do? Would a reasonable man, knowing that there's a gun in the barn, leave the barn unlocked ever? Or not? You can decide and make recommendations, and again bring in previous cases. Okay, so plenty of stuff you can discuss there. Will Tom Browne, second part, will Tom Browne have the defense of contributing negligence because Rod bullied Declan? You can argue that yourselves. In terms of my own personal view, I'd probably say no. I think it's you do have to keep focusing on the link. How close is the link? I mean, is there a strong likelihood? I mean, if Declan had maybe punched Rod at some point, could you say, well, there's a strong link between Declan punching Rod and the bullying? Yeah, you could probably argue that. Is it probably, would Rod have ever believed that Declan would go and get a gun and shoot him? You're probably talking, it's probably less likely as you're going along. So in my personal opinion, the defense of contributing negligence is probably unlikely to stand. You could give it a go, but in my opinion, a bit unlikely to stand. Okay. Third part, Rod's parents believe that Tom Browne was negligent because he left the gates open, because he left the shotgun in the unlocked barn, and because Declan was able to find the shells in the barn. Also, for each of these allegations, determine if there's actual causation. So covered some of that already, but I mean, just quickly going through it. Okay, unlocked gate, Is it common for gates to be unlocked around the country in more rural parts of the country, which it sounds like that this is based on? Yep, that wouldn't be unusual. Been through them myself. Is it common for a barn to be unlocked? If there's a shotgun in it, maybe less likely that it should be unlocked. Yeah, is there likely to be an unlocked barn if there's no shotgun in it? Yeah, that again, I think that probably the barn is probably a good chance that it'd be unlocked. Yeah. How common is it to have a shotgun in an unlocked barn? That, to be honest, I don't know. You can put forward the suggestions yourself. And then the final part is, okay, because Declan was able to find the shells in the barn also, would it be common or would it be prudent to kind of have the shells in the barn, which is unlocked, in the same place as the gun? Probably not. Okay, so you can discuss it yourself. You can rely on other cases. You can do the but-for tests, and you can also do the reasonable man test. And you can, like I said, no right or wrong answer. It's up to you to kind of convince, or is it a good argument or not? Okay. And then finally, can Declan maintain a cause of action against Tom for his injury? Yes, he can, because he's a minor. Okay, Declan is a minor, so as a result, the fact that he's gotten injured himself because of potentially somebody else's negligence, could he himself have a causation, launch a case against the farmer? Yes, he could. Okay, so those are the type of things that we'd be looking for in a tort question, and there is a tort question on the exam, which I'll come to, on the real exam, which I'll come to in a minute. Any questions on that before we get to the 4 long questions in the real exam? Nope, I'm seeing shaking of heads. So, okay, good. Okay, so we'll go on to the real exam. So real exam, same format as the mock one. Okay, so you're going to get 50 questions. Your first hour is dedicated to 50 multiple choice questions. Okay, and like I said, I will send out, when we finish this session, I'll send out the answers to the mock one. Some of the mock ones could appear on the real one again. The only thing I would say is just do read them very carefully. Okay, the word not could have been on the mock one and it's not on the real one, or the other way around. The answers could be switched around and so on. So there could be some. There won't be many, but there could be some that are pretty similar or exactly the same. But do read them carefully, okay? The answers, just make sure you're not imagining answers that were there on the mock one but are not there on the real one, okay? So that's 50 questions. That's your first hour. That comes from all 4 modules, okay? So you will need to familiarize yourself with modules 1, 2, 3, and 4, because the questions are from up and down and left and right, and they're from all over the course. Okay, so and it will be tricky to find in that hour. It will be tricky to find answers to 50 questions. So it should be good to have a good working knowledge. You don't have to know everything by heart, but a good working knowledge to be able to nail those answers. Okay, but most people in law on the multiple choice side, they've scored pretty high. I don't think I've ever gotten anyone who's gotten all of them right, but we have gotten 46s, 47s, 48s out of 50s before, so that's not unheard of. Okay. So anyway, that's the first part. So like I said, I'll send you the answers out to the mock one in a minute. On terms of the longer questions, so I'm just scrolling down here past the mock one and onto the real one. So in terms of the longer questions, it's 4 questions and you need to do 2 of them. Okay. Question 1, not too surprisingly, is on contract law. Okay. It's not Paddy and Mary selling the Mercedes. Okay. So different facts, but it's essentially the same question. What we're asking you to tell us is, okay, well, has a contract been formed or not? Okay. And if it has been formed, and you deem there to be a valid contract, what are the potential remedies there? How could you put the situation right? Okay. So question is more or less the same. Okay, it's just you're going to get a completely different set of facts. Okay, it's not selling a Mercedes this time. Okay. Question 2 comes from module 2, and it's on company law. Okay, so module 2 is company law. Okay. And this time I'm going to be very specific, and I really am being nice. So this is on the Consumer Credit Act. Okay, so a specific act that is that has a specific relevance, particularly to those of us that work in the credit and collections business. So there's a significant connection. So it's on the Consumer Credit Act. Okay. Okay. So if you're very familiar with the Consumer Credit Act, you could have a go at that question. Okay. Question 3 is on EU law. Okay, module 3 does cover some other things that are not directly related to EU law. They're not a million miles away, but they're not directly related to EU law. But you can forget about them for the purposes of this question. Although could still come up in the multiple choice section. But in terms of question 3, it's on module 3. It's EU law, and it's from an early part of EU law. Okay. So the mock stuff was kind of a bit later. It was talking about implementing a directive. It's from an earlier section. Okay, so an earlier part of EU law is what we're looking for question 3. And then finally, for question 4, as I've already said, this is on tort. Okay. And again, it's kind of same type of questions, but completely different facts. So Rod and Declan and the gun and all that, they're all gone. Okay. And we have a different set of facts we're going to give you. But we're essentially asking 2 things, which is, 1, is there negligence? Okay, so something goes wrong in the question. Is there negligence or not? And 2, let's say there is negligence. What defenses could the defendant potentially use to get out of the scenario? Okay. So I suppose, in terms of general guidance, okay, like I said, no right or wrong answers, okay, but do back up whatever side you're taking and whatever view you're taking within the case with an explanation. If you can link it back to an earlier case, if you can use things like but for, reasonable man, things like that, that is very, very helpful in terms of getting you some extra marks. And I suppose, don't, the mistakes I've seen in the past is it looks like someone is going one way and say, therefore I rule there is a contract, even though the entire essay seems to be suggesting there is no contract, because that literally my jaw drops when I read that. Sorry, what? So I suppose avoid the sorry what kind of moments would be my guidance. So just one more time, whole course for the multiple choice. And then you can decide yourself, do you want to focus on contract, tort, company, or EU law in terms of answering the 2 questions. And similar, I think you probably would have heard Declan's comments because we were finishing a bit late on the international. But if you do feel like you want to do a third question, third longer question, by all means do. We will take your highest score and your top 2 questions, and those will be the marks that you get.
That's great, Paul. Thanks very much. Sorry, and just one other thing as well. Just if you forget everything that we said to you today, and you find yourself with 10 minutes to go and 1 question to answer, just jot down as many bullet points as you can. All right, that's just just to pick up marks. So and we can see it in the paper that they spent far too long doing question 1 and question 2, then you're under pressure. So if you just even answer it in bullet point format, just to get something down on the page to give yourself extra marks. And the other thing, as you were talking there, Paul, about the MCQ questions, I was just thinking, and maybe it's unfair, if you get 50 right or you get 40 right, you still get a distinction. Right, so stop. In terms of beating yourselves up because you got 2 wrong, it's not going to matter. Is that okay? So just that that's the job at hand. So look, just do the best you can. Come to it with as clear a mind as you can. And yeah, I think law is it's a great subject, and it's a way of thinking. So it's not about your opinion. It's about the facts in the case and precedent, and so based on that, this is where. But again, when you look at every law case that has ever happened, it's the only profession where they get it wrong 50% of the time, because there's a winner and loser in every case, and both thought they had a case going into it. So it's kind of an inexact science, but hopefully the course will give you some questions and just give you an understanding of how the law works. And I suppose in your role in credit management, that you become the go-to person where, you mightn't have the answers, but you'll at least have some of the questions. So, Paul, thank you very much. I think that was very helpful. I hope everybody found it helpful and useful, you know where to go now, and go and enjoy the rest of your weekend. And I'll be emailing you on at 10 to 10 next Saturday morning with the MCQs for law. And you have 1 hour to get those back to me. So just make sure you get them back within the hour, and then you'll get the long questions. And if you get them back 10 minutes early, you will get the long questions 10 minutes early, which means you'll have 70 minutes, which just gives you extra time on the long questions. But again, take the hour if you need it. No need to rush. If you do get them all finished to your satisfaction early, submit your answers early. You will get the long questions early, and that will give you the extra time at the end, which might make a difference. Is that okay? So if we're all
Thanks a million,
done,
Paul. That was brilliant.
yeah,
Yep.
we've demystified it. That's exactly what we want to do. Listen, guys, go have a wonderful weekend and stay in touch with us. Thanks a million, folks. Thanks, Paul.
Take care,
Bye,
everybody.
everybody.
Bye.
Best of luck.
Bye.
Bye.
Bye.